First of all, good afternoon, everyone. Thank you for joining me today. I'm currently I'm currently a master's student of the Faculty of Law at the University of São Paulo. Of course, we have limited time here, so things are a little bit streamlined, but feel free to make any remarks or ask questions, either if you have time after the presentations or in the corridors. So, to the presentation. Bioethics was born as a result of the conclusion that the previous systems of value were insufficient in assisting humankind in taking the right choices that could lead us to a promising future before new multifactorial challenges that were to surface during the 20th century. They required a new way of thinking ethical, regulatory, and scientific solutions built upon an attempt to conciliate universality and diversity. Hence, one of its distinguishing features was the interdisciplinarity between natural sciences and humanities, as well as a dialogue with other systems of thought and belief. So, Porto, who is considered one of the fathers of bioethics, has a lot of different definitions like guide to action, knowledge on how to use knowledge, science of survival, and etc. So, all these definitions point out this direction towards reflecting about how we should deal with these emerging challenges and how we should tackle all these issues that the progress of science would bring to humankind. And also, a lawyer called Jonathan Montgomery, proposes that bioethics is not only a discipline, but is also a governance practice. So, it has a lot of different roles related to doing things, actually. And some of the roles that Montgomery likes to shine a light upon concerning pluralism and relativism are, first, bioethics can promote the mediation between different systems of thought and beliefs, and this may help in searching for a decision that is satisfactory or at least tolerable to a lot of diverse groups with different worldviews. Second, it allocates space or jurisdiction to different groups, so it tries to balance the public debate in democratic societies. Third, it provides legitimacy to the decisions taken, so it makes sure that diversity is somehow embraced. And fourth, it attempts to find common ground, or at least be the most inclusive possible, while defining parameters of what makes an idea justifiable, such as being fact-based and rational. However, bioethics might find it difficult to actualize this vision of peaceful coexistence of different communities, each with its own worldview, or even to develop a theoretical framework that helps bridge descriptive bioethics to actual normative bioethics that provides a path for establishing a common ground for subjecting human conduct to the governance of rules, as legal philosopher Fuller tries to define law. And in this sense, we can point out two major hindrances. The first one is that different communities might have different moral languages. So they might disagree on some of the most basic moral premises, and this renders the dialogue between these communities very hard. So we might notice that the conceptual incommensurability of different discourses, so there are disagreements concerning sometimes there are basic moral categories, such as the beginning and the end of life and what defines freedom. And the second one concerns itself with how the parties behave in a dialogue. So confronting parties may present incompatible positions and opposing demands. And what I mean by position and demand, position is different from what we call interest, because position are the demands that an individual or community express publicly, so how they perform socially. And interests are the goals and values behind their positions. So positions can frequently hide interest for various reasons, such as the attempt to gain more from the situation, or the party is performing according to its community's expectations. But how bioethicists might be able to identify interests, because we can't actually read minds, and sometimes the circumstances might limit the possibilities of inquiring the party. And as I said before, you can't try to guess what is the interest behind a position. This would be very irresponsible. And besides, sometimes the interests are clear, but it's difficult to find a common ground for guiding action. So both of these hardships shine light on a never-prevailing challenge in bioethics, which also has very concrete implications, and that is the gap between descriptive and normative ethics. And this is the same gap we see between the particularity of descriptions and the universality of rules, the identity of individuals and communities, and also the general guidance of conduct. And this conduct would actually be responsible for guiding which decision should be taken by either the professionals or those involved in a case. And the law and literature movement might provide some valuable contributions to this challenge, because, as I shall expose, this is a gap that can be filled with resources that actually the narrative provides. So, first of all, defining law and literature. So, law and literature argues that there is a relationship between legal institutions and literature, or more broadly, cultural works in general. So we have two most prevalent approaches, and these are law in literature, so the state of legal scenarios present in literature, film, opera, and poems and such. And the second one is called law as literature, and law as literature try to find some formal similarities between both law and literature in general. So two very common examples are the importance of language and code. So these two are central in both law and more especially the written literature, but also the role of meaning, among others. These two approaches can also be together, can be joined together in an interdisciplinary analysis of these cultural works. And these are frequently supported by a theoretical framework of the humanities. But likewise, there's not a hard line between these two approaches. And they have a lot of similarities, like they all presume that there are some kind of tie between rules and narratives. And so the first framework I'd like to bring a lot, when we think about how law and literature can actually help, is a very celebrated text in Brazil called Literature as a Human Right, or the Right to Literature. And this is, so the literary critic Antonio Cândido, he makes a defense of literature as a human right, and he argues that literature, and he used literature in a very broad sense, so he tries to represent what we call all creations of poetic, fictional, and dramatic touch. So we can think about novels, folk songs, news articles, poems, and all these kind of things. They are responsible for what he says is guaranteeing the spiritual integrity of the individual and also of its community. So he says it is the daydream of civilizations. For its structure, the creator proposes a model of coherence of the world we live in. But on the other hand, the organizing force enhances the ability of an individual or society of ordering its own chaos, thoughts, and feelings. So hence, it's worthy. I bring here a quotation from Luke, which says, "Organized words are more than the presence of a code. They always communicate something which touches us because it obeys a certain order. The original chaos, that is, the raw material from which the producer has chosen a form, becomes order. Because of that, material chaos also orders itself and the message can act. Every literary work presupposes this overcoming of the chaos, determined by a special arrangement of the words and proposal of meaning." So literature is humanizing because it provides mental sanity and constitutes the building blocks of the identity of a certain person or community. Furthermore, it expresses ideas and feelings and denounces injustice and rights violations. It inserts its creator in the larger scope of society, making it present where it was not. It broadens our horizons and allows us to the perspectives of different persons and communities. But this connection was also fully explored by a legal philosopher called Robert Cover. And in his work, Nomos and Narrative, he points out that the individuals, they actually inhabit what we call nomos. So almost as an opposition to physis, it's a normative universe, a normative world. And this nomos is built upon a symbiotic relationship between prescriptions, rules, norms, and narratives on the other side. So I've also been a quotation from Cover, in which he says basically that every prescription demands that some explanation from the narratives, some story that backs up the prescription and locates it in the cultural heritage or the cultural tradition of a certain population. And at the same time, the narratives, they demand the existence of a prescriptive point as a moral lesson, like the moral of the story. And so they cannot be separated from each other. And actually, being aware of this nomos is as important as knowing the laws of physics, because it's a nomos that allows us to understand the worldview and the actions of a certain community. So this nomos is actually held together by what we call interpretive commitments, or we can say shared interpretation of reality, on the current state of affairs of this reality, and also of the possible implications of any action an individual that belongs to this community would act. So, likewise, some actions might only be understood under the light of these interpretive commitments and in relation to a norm, such as the importance of providing a proper burial, the acceptance or refusal of blood transfusions, and also the proper ways of collecting consent. So there are also resources that we use to communicate with each other. So it's really different for me and for someone else whether we will rest on Sunday or we will go to the church. It's totally different, but you can only understand what each of these actions mean if you somehow are able to interpret the community in which this person is inserted. So, actually, we say the law is a system of tension or a bridge which connects a concept of reality on one hand, and on the other hand, what we can call an imagined alternative. So, almost a counterfactual situation of this reality. So, likewise, these states of affairs, they demand this narrative as some sort of explanation. And these insights are valuable to bioethics because they show the narrative has been doing what bioethics has been struggling with since it was born, which is trying to bridge a description and prescription, build a bridge between descriptive bioethics and normative bioethics. So it has concerned itself with ordering this chaos of natural and social lives, even though it's in a cultural medium. And law and literature is always trying to bring up these dynamics to explain the legal phenomena and all the issues we face in a legal context. Right. So, and how this may help us in the first place. This may help us to better understand the role of narratives and enrich what we said is the governance of human conduct in a world that's actually diverse, that we actually have communities with different narratives behind their rules. And in this sense, it has some similar challenges with bioethics. So we actually have some attempts in bioethics that somehow try to reach the same goal, but with a different path, which is called narrative ethics. So there's a very nice Hastings Center report from 2014, which discuss this narrative ethics. But the fact is that narrative ethics itself has made great contributions in this direction, because it suggests to shift the focus of bioethical conflicts themselves to the resolution of personal and collective narratives. So they try to build what they call memory maps, which is like a mind map with all the reasons that would lead to a certain decision, and together with the family or with any with friends and every person that is that shares a life with the one who is concerned in this bioethical conflict, and tries to offers a satisfactory solution. So, of course, what I'm proposing here does not intend to exhaust learned literature or propose in learned literature is a solution for every issue that bioethics has, but I believe that we might have some contributions from learned literature. And a second possible contribution is that if we broaden our vision of these normative universes, we can also find new solutions in places that we weren't aware of. So both Margaret Mead and Ben Potter, who are two important figures to understand where bioethics is today, they both propose what they call a council of future. So it would be a council, we would foment the dialogue between different cultures and different systems of thoughts and beliefs. And if we can better understand the narratives behind their rules, we can also have a better concept of the future. So perhaps that might make us see this diversity once more not as an obstacle to bioethics, but as something that can empower our endeavors in finding all these solutions. That's all. Thank you.